confrontation is absolutely inevitable. We have conflict with opposing counsels, with clients, even with colleagues. It's going to happen. And I can be a pretty confrontational person. So it's something I've really had to learn that the way you respond or choose not to escalate leads to far different outcomes than when you actually get engaged in the argument itself. A lot of lawyers, especially earlier in their career, think that standing your ground means you fight every battle. But sometimes taking that step back and turning a confrontation into a conversation leads to a much clearer understanding and better results for your client, for you, and for your relationship within the legal community. Conflict's absolutely a part of advocacy, but it doesn't have to be personal tension. Even if the hearing is tense or negotiation is tense or you get into a debate in a courtroom, you have to be professional. So choosing to engage in a conversation instead of a fight, it doesn't mean you're weak. It's a choice. And it's a choice that often leads to better information, clarified positions, and stronger outcomes for you and for your client. So at the end of the day, if you want to have a constructive conversation instead of a confrontation, there's some strategies you can think about that have worked really well for me. I am the queen of, drafting an email that I read later and say, that's probably going to come off way harsher than I mean it to. So I'll pause and I'll ask myself, do I need to respond to this right now? Because often waiting will give me a much better perspective. And when I wait and I come back to it, I've also taken that time to say, okay, maybe I didn't understand their point of view. So let's take a couple more steps back and maybe reframe this response that I drafted in the heat of the moment. You also really have to decide what battles are worth fighting. Not every point needs to be argued. If you're talking about a case, not all the facts are necessary. You don't have to outline every little detail, try and beat it in. You need to highlight what's important because that allows it to be productive instead of just tense. And the other thing is you have to lead with empathy and you have to lead with clarity. Things are going to get heated sometimes. So taking that pause to listen, actually think about the point they're making instead of just responding, clarifying if you need to, and then just using the facts to respond. It leads both you and the other side to be able to communicate more clearly. So it really does come down to sort of reframing the discussion. While we can't avoid conflict, we can say, well, let's clarify our points to make sure we understand that we're on the same page, because that could turn a fight into an actual dialogue. I've had circumstances where I've been working with opposing counsels who are very, very aggressive. But if you take that time to pause and you actually come back to them with legitimate questions that show you're listening, you can turn it into a much different scenario, and you can come to a much better resolution for both of your clients than an argument would have. At the end of the day, confrontation, it's part of our work, but it doesn't have to drive every outcome. Potential conflicts, whether because you don't agree on the facts, you don't agree on the outcomes, they can absolutely be a problem. But if you pause, if you listen, and you take that time to clarify, it's much easier to come up with a collaboration instead of a conflict.